on this.
It doesn't count when it's watched.
Oh, yes, it does. Yes, it does.
Now you're going to make it nervous.
Council.
Director Lepore, Mr. Teff referred to staff's unreasonable demands in his statement. Is compliance with commission rules and orders an unreasonable demand?
I don't think that's an unreasonable demand. I think it's an expectation. And I think most of the timeframes for compliance, as I've testified previously, were negotiated and agreed to by CM, if not recommended and proposed by CM.
And to your knowledge, did anything prevent CM from continuing remediation while the 2015 AOC was continued?
Absolutely not. Okay, and let me elaborate on that. While that AOC was waiting to go in front of the commission, they were still under the 2013 orders whose deadlines were rapidly approaching or had already passed. They should have been moving as fast as their resources would have allowed.
Okay, and let's turn to, Mr. Teff made some statements about the costs of the remediation moving forward. Do you recall Mr. Teff formally making any statements regarding the cost of remediation that were inconsistent?
So as I indicated, my recollection is that Mr. Matter and I and Alex Fisher, who engaged with Mr. Teff before they purchased the site in early 2013, went out of our way to make sure he understood there were a lot of environmental issues at this location. Repeated conversations. Much more recently, in our meeting in June of 2015, after Commissioner Walk took the AOC off the docket and we met, I found my notes from that meeting. They're fairly sparse, but they say, John Teff thought that the site might cost $500,000 to restore. He was off, he says here, by a factor of 4. So in June, my notes reflect that when he purchased the site, he thought he was buying a $500,000 cleanup. 2 years later, he thinks it's a $2 million cleanup. Today, he's told you he thinks it's a $10 or $12 million cleanup. So I'm not sure, you know, where the number is, but he did his due diligence and he thought he had a $500,000 cleanup, which wouldn't have been that far off of, I think, what staff might have thought in 2013.
Commissioner Benton asked Mr. Teff about CM's plans for the next year. Has any of the information or statements from CM indicated to you that it has the money to do any of these activities?
No. And again, I'm going to return to my notes from this June 11th meeting. I wrote down again Mr. Teff saying that he can't spend $100,000 in bills and fees, et cetera, and he has no short-term plans to turn the field on.
And lastly, why is staff advocating that CM not be given another chance to delay?
I mean, these are very difficult scenarios. We had these conversations at the last hearing. The choices aren't terrific here. But honestly, I think that Commissioners Benton and Hawkins are asking the right questions. The UIC permit was a bump in the road. It was a small speed bump for CM, for what they thought, how they thought this would play out. So it took us 4 months to issue them that permit. And that seems to have unraveled their entire plan. It wasn't COGCC's fault that it took most of 2014 to get electricity to the site. Why wasn't that anticipated? Why wasn't that planned for? Why was it suddenly a need to do a 3-phase electrical run out to there? You can't pin this all on a 4-month delay that happened between October 2013 and February 2014. This is a small operator that bit off more than it could chew. They do not have the funds. They do not have a source of revenue at this location. That should have been Plan A. It was Plan A. Did they bail a widow out? Yes, we were anticipating putting an NOAV down in front of Lone Pine for $150,000 that they likely would not have paid. That was to protect this people of Colorado. Is CM the white knight here? That's their characterization. We have lost confidence that they will ever be able to turn this field around. We have lost patience. We understand that the choices are narrow, but they've had every opportunity to get this field on production, create revenue, clean up these pits, stick to the promise. May of 2013, they asked for the deadlines. They came back in June and asked for an extension of a few months. The minute they got the extension for November 2014, what did they do? They didn't turn the field on. They came and started renegotiating for a longer extension. Roger Freeman did that with Peter Gowan, essentially behind my back. I participated in not a single one of those extension negotiations. That's what they did. They tried to buy more time. CM's MO now is delay, 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 delay. We've lost confidence that there's any good outcome at the end of that rainbow.
I do have one more question. Mr. Teff made a statement regarding the burden of the location falling on the state. Why is staff willing to accept this burden if it indeed falls on the state?
I think that we have concerns that the situation will get worse. Again, Mr. Teff has testified that there have been no spills. I mean, maybe I don't understand the technical aspects here well enough, but they aren't producing the field. So yes, I get that there's some freezing possibilities. I think if you have no hydrocarbons coming out of the ground, running through those pipes, going into injection wells, et cetera, your risk of spills seems to me to be somewhat diminished. So the situation can get worse. We've seen that in the past with other operators. COGCC will take over the field and manage the high risks in a way to minimize potential impacts to public health, safety, welfare, and we'll probably look for a different buyer. Depending on how that plays out, there is the possibility of P&A-ing the wells.
Thank you, Mr. Lepore. That's all I have for you. Commissioner, this would be a good opportunity for you to ask Director Lepore any questions.
So, Director, we have this dual responsibility of developing a resource and balancing that with protection of public health, safety, welfare, environment, wildlife resources. So I'm not deliberating, but I'm trying to figure out how we get to that sweet spot and accomplish that balance. I'm open to, suggestions. Oh, you could, please.
I think I heard somewhere in there that if we follow the recommendation of the staff and go forward with fine, potentially the state then becomes the operator of this field. Is that correct?
I think it's fairly clear that CM can't not pay the financial assurance that they owe under the state statutes, that they can't afford to do the MITs that are due. respect Commissioner Hawkins' position that we too would rather see their limited financial resources go towards producing the field, but they have failed to do that since February 2014. It is 2+ years. 2+ years.
Understand. But it's not a given that you would immediately proceed to plug the field out. You would look at potential alternatives.
Absolutely.
Okay.
Much prefer to find another operator.
Okay, thank you.
In some respect. Okay, any other questions for Director Lepore? You're not going to try to rebut, are you?
I can clarify a couple things.
If you're going to clarify, I'll entertain you.
The $500,000 cleanup and the $10 to $12 million of abandonment liability, that's two different questions. It takes $500 to clean up the contaminated soil, but $10 million to abandon the field. The 4-month delay, and I've kind of heard this a few times, that we purchased the field in June of 13, and by the time the disposal well was approved, it was February. The math is more than 4 months.
I understand that. I remember. You expected the injection well to take 4 days, took 4 months.
Yes, and I would like to say one thing, that Bob was just absolutely helpful and professional. That's why that permit got approved so fast. He was so great to work with.
Okay, any other questions for staff? Hearing none. Thank you all very much for your presentation. Ms. Beckstead, nice, you and your friend. Nice
Yeah.
presentation.
And now it's time for staff's closing. If
What,
you would
now
like
have
it.
like 20 minutes?
Take back that hug.
Yeah.
Yes, ma'am.
We will make it very brief.
You don't let Mr. Davenport do it? He already has a history of being brief.
In brief, I would like to remind the commission of the timeline here. Field purchased June 2013. Prior to that time, CM's looking at the site, negotiating deadlines. Deadlines negotiated in June of 2013 can't be met. June of 2014, extended deadlines, can't be met. AOC 2015 needs 2 more years, or to September 18 is how long CM negotiates and says they need. This is a story of delay, of failure to meet obligations, of failure to meet promises, of failure to meet deadlines. If you just look at the timeline, it's proof enough of why staff is frustrated, of why staff doesn't believe that CM can do what it promises to do. This could be just, depending on what's ruled on today, just another delay, just another time that CM was given another chance and couldn't meet a deadline again. And that's what we're here to ask you today, is to issue the relief that we're requested, because it has been long enough. CM has gotten enough chances. Every chance they've asked for is a chance that they themselves have said, we can meet this deadline. I take you back to Alex Fisher's presentation and the promises on the work plans that CM made in 2014 and 2015. Numerous promises that they made in work plans and didn't live up to. Mr. Teff admitted to you that the promises that CM made and agreed to in the 2013 orders to remediate this site to Table 910 standards still has not been met. And what they've come to you today with is excuses. UIC well permit took too long, but they still got it in February of 2014 and nothing's happened out there. Oh, we didn't think we could do anything because we were negotiating a 2015 AOC. Nobody told them that they shouldn't be doing anything out there because they were negotiating an AOC. It's excuses. It's delay. And they've made more promises today. We can do this with a certain time frame. We've got the money to do this. But they always use these finances as a sword and a shield. Don't give us any penalties because we don't have the money to pay them. But oh, absolutely, we've got the money to put this field into production. It's just not believable, the statements that they come in here with. And we've demonstrated time and again that what they say can't be believed and what they say can't be lived up to. Now, I've already spoken to the environmental violations. That's undisputed that they violated those two orders because they have not remediated the Table 910 standards. MIT violations, financial assurance violations, also undisputed. They have violated those rules. And if we're speaking to the penalties in those, commissioners, the penalties were calculated by the book. They're calculated pursuant to the statute and the enforcement policy. And yes, we give operators breaks on the penalties, but that's when operators earn those breaks by demonstrating that they're complying, by self-reporting. Rule 523 has mitigating factors in it. CM hasn't met any of those mitigating factors. Yes, absolutely. Penalties, we give breaks, but you earn those breaks by showing that you do things that comply with the rules, that comply with staff's orders. So I'd like to direct your attention very briefly to the handout that was given to you at the beginning of this hearing. It's the legal sheet. And if you look at that legal sheet, this is in effect what staff is asking you to find. If you agree with all of staff's requests and order in accordance with staff's requests, this is what we're asking for. I don't need to use time to go through them. You can see them all here, but this is a good brief summary of what they are. And just 1 minute. I'd like to reiterate one more time that CM asked to become the operator. They made a business decision based on all the information everyone gave them. And testimony today was they got all the information they could get. And I encourage you, when you're reviewing this, to go back and look at the actual visual progress of this field in 2014 and 2015. Nothing was done out there. And they've come in and promised we'll get a lot done, but when they promised that before, and they haven't lived up to those promises. So for all the testimony you've heard today, all the reasons that we've given you, we request that you find for staff in accordance with the Exhibit A finding summary, and that you approve the proposed order that was handed out to you today with the allowance that it may be modified for things that are said today at the hearing. There are findings of fact in there that we can't guarantee you are exactly everything that was stated here. And that's the one modification that we request, is that you allow us to modify it to be in accordance with what was said here today, the findings of fact in the proposed order. That concludes staff's presentation. Thank you.
Council, you purposely, I'm just guessing, you purposely said CM can't do this, or they can't do this or this. You didn't say they won't do this or this.
Well, frankly, I think it's a reasonable conclusion to make that they won't do these things because they're waiting for the price of oil to go up. I think that's a reasonable conclusion. It's certainly, it's something you can conclude from the inactivity over the past 3 years.
Okay, questions? Thank you. I'm sorry, I think we may have one more. This will probably be the last one.
Just, we were handed out the order of finding violation and denying CM's application. And there appears to be a difference between it and what we received electronically, because I just look at the last sentence on a page and they differ. So I'm wondering what is, if you can real briefly, what is the substantive difference?
Of course. So what you have in your hands is the revised proposed order. And this was submitted after your portfolios were created. And the reason why it was submitted is it offers two options for the violation of the 2013 orders. Previously, staff had only requested payment of the $150,000 that was previously suspended. In this revised order, staff has provided a second option for CM. they can post a $200,000 bond and negotiate a deadline with staff.
A or B.
Exactly. And this was added because it more closely mirrors the director's demand for payment, which also offered these two options. The other major difference is that it clarifies that it does not extend the deadlines in orders 1V412 and 1V413. Those are the major substantive differences between the two orders.
And those differences, Commissioner Allward, are specified in the handout under bullet 3 in letters small a and small b. And as Chairman Compton said, it is an or scenario. And of course, you can
I know.
Do what
I know
you
we can do
want.
whatever we want. I know. I've heard that a few times. Okay, Ms. Bexton, anything else?
Yep, that's all for staff.
Is there any reason, Ms. Murphy, why we should close the record at this time?
Only if you have questions of the parties.
Do we have any questions for the parties? Okay, let's officially close the record, and we will commence to begin to get started deliberating. Okay, folks, men, women, men. We don't have any women deliberating, do we? Be advised. Okay, you already heard my thing. You know, I'm still struggling with that balance.
So this is what I read, and you know, there's perhaps Commissioner Spielman can clarify some of this. So there's,
Commissioner Spielman?
yeah, Commissioner
Okay.
Spielman, this. So we have two options. Within 30 days after the order, CM will either pay the fine and do the remediation work, or pay the $150,000 penalty, sorry, or post financial assurance in the amount of $200,000. It's an either or thing. And negotiate a new deadline. So when I get to that far, it looks to me like the commission isn't actually saying your time is over. They're actually getting another chance here. Actually, two options to choose. Both of them are certainly not inexpensive. And then it goes on. It says that there's a number of penalties. Items 6, 7, and 7, I guess, right? Plus, you have to post a $210,000 bond. But I would assume that if you post the financial assurance, if you take option B, then that would satisfy the $210,000, or is that on top? That's on top of. Okay. All right. Thank you.
Where did you see the part about negotiating a new deadline?
Pay the $150,000. Let's see. Right. Post financial assurance amount of $200,000 pursuant to Rule 702A, and negotiate a deadline to remediate the pits and the land farm. And it's the $200,000 insurance posted under 702A is separate and independent of CMO. Okay, there it is. Sorry, I didn't read the whole thing. Post $200,000, $210,000 additional. So there are some options available. It's not like we're just slamming the door here. And so, I mean, you can't say anything, sorry. I suppose the one thing you could do is say that, well, you get to pick option A or B, and I suppose we could say that we would suspend the fines for a period of time, potentially, and said, well, if, give them a bit of a chance, and if they fail to comply with the order, then those fines go into effect. I suppose you could do that.
We can do anything we want.
Yeah. But is that how you would read that? Okay. That's why I was asking you, because I just sometimes I get all wound up in the wording of this stuff.
The way I look at that is A, you have a penalty and do the work now, or B, post a lot of financial insurance. and negotiate some future work.
But regardless of A or B, you still have to put the 210,000 up.
Because
Right.
you have wells that are
Yep.
shut in. And
Right. You need to satisfy the state bond. Okay.
I guess I'll take a little stab at kind of where I'm going, where I'm thinking on this. I really would have liked to see, and let's put it that way, that the operator spend more money towards getting the pits remediated. But I also haven't been negotiating with him for 3 years now, or 2 years. Maybe I would feel totally different if I was in staff's shoes, negotiating deadlines and seeing them go by. And so I think I'm at the point where I have to trust that staff is making a reasonable recommendation to us, that it's time to give them an opportunity to pay a penalty or put up a lot of financial assurance that they're going to take care of all this, and not give them more time to delay.
I would agree with you. I think comment I struggle a lot with this is and Mr. Davenport did make it pretty clear that when the purchase was negotiated, there were deadlines agreed and not met. And then they went back and negotiated again and again and again. And also when Director Lepore mentioned it, and when I heard that they were able to get a UIC permit in 4 months on fresh water,
Pretty fast, yeah.
that is extraordinarily fast for shallow freshwater zones. Get that. I don't know where Stuart is, but boy, I hope we get that kind of treatment when we have to do a disposal well. So the tendency is to support the staff and approving the order. I think the only question for me is that do we do something about the penalties? And do you potentially defer a portion of that or all of that? In September 2016 isn't too far out in the future. Give them a little bit of breathing space to say, can they exhibit a different type of behavior than continue to ask for deferrals and delays and so on and so forth.
See, the problem I see with that September deadline is using the procedures they're using now. The dirt farm, what do you call it?
Yeah,
Land farm.
land farm.
Land farm, I mean, that's kind of time, and takes a little bit of time for that to work.
Right.
And I don't know you're going to see those 9, 10, 1 figures met by September 26th.
You may not, and it just, whatever. What was the line in the old movie? Is what we have here is a failure to communicate. Yeah. Thank you. Is that
No, I'm sorry. Cool hand loop.
cool hand loop? Yeah.
I'm sorry. I didn't mean to distract you.
To me, there's something's missing there. Is that there's not been reasonably good communication, and if you're going to do the land farm during that period of time, you may not get it to 910-1, but you can certainly submit. It says, here's the work I've done, here's the amount of money that I've spent, this is what I've employed, and this is where I've taken it. We know where it is right now. It's what, like 9,000 milligrams per kilogram or something like that is roughly on the dirt pile. So can we improve that? I do have a question about the pits. Is essentially digging up the dirt on the pits may be an issue, but you should, if you don't like that, then you should submit an alternative. Say we propose doing this and see if the staff, if it makes sense.
They want to wait until the until the hydrocarbons quit showing up, or at least are minimized, and they're going to add a chemical agent that will precipitate out hydrocarbons or something. And
Yeah,
again, that's a time.
it's a time thing, and I don't know, what I don't know about the operation is those all line pits.
Well, you said they were all bentonite.
Right, they've all got bentonite lining, so that, there's only a certain point in time, can't be that much oil left in them.
You'd think.
Yeah.
That's what I think they thought.
Yeah, so, we're taking a bit of a chance there on that one.
We're
I think you'd have to show show the staff, if you're going to go down this route, you have to show the staff that you're putting a lot of time and effort into this. And spending more time on the work and less time on asking for deferrals and delays. I know that's pretty harsh, but it needs to, I'm with you. I mean,
It's hard when we're not the ones that have been negotiating for 2 or 3 years and
your patience has run out.
patience run out. That's it.
Fair enough.
okay. Commissioner Spielman's going to give us a reasonable solution.
No, frankly, Mr. Chairman, I think the staff has already done so. I hear a story of, even in struggling economic times, an operator who made a business decision, who has multiple per se violations. I think there's 49,000 other wells in the state that are not before us today because those operators are complying with the laws of the state. I think we've heard that this company has revenue streams from 4 or 5 other states. The AOC that was or wasn't approved last year, that was already an action in response to prolonged violations of our laws. In my mind, frankly, this one's, despite the 5 hours and the case put in front of us, I think this is one of the more cut and dry enforcement actions I've seen in 5 years on the commission.
Commissioner Allward.
Thank you, Mr. Chair. I want to thank all the parties for a very thorough job and for putting a human face on a very complex and agonizing description of what's going on. I want to largely support what Commissioner Spielman just said. I think I can get the sense from reading through these documents and hearing all the parties today, the frustration, how long this is drug out. And one of the things I'm struck with from the deposition and today's 510 statement is it seems that this operator is not familiar with the regulatory language of Colorado, that he's using his own definitions for terms, and that's where this failure to communicate is. What does it mean to close a pit, to decommission a spill, to remediate? What is compliance enforcement versus harassment? We're finding a lot of different definitions of terms that we expect operators to use a common language, and that seems to be a real problem. I think with the 910-1 standards, those are performance-based standards, and we do not say, oh, you've put a lot of effort into this, you've spent money, therefore that's what meets our standards. No, we have very clear, bright line standards, and if one method doesn't work, then you're obligated to use a different method. And you can't use a method that might be appropriate in one location. We do not have one-size-fits-all rules. We expect operators to have their own smarts or hire smart contractors to figure out how to get things done under the conditions that they confront where they have their operations. I'm struck by the lack of any documentation to corroborate the claims of compliance. We've heard lots of claims about what's been done, what MITs have been conducted, but there's no documentation for this. And so that's not the sort of operator that we want. You know, we do have paperwork requirements. We do require certain compliance so that staff knows what's going on. There seems to be a misunderstanding of what the process is of not being able to do anything during the negotiation of an AOC. So again, all this keeps pointing back to, we've got an operator that doesn't know how the regulations work in the state of Colorado, and that is not something we want to encourage. That if you're going to operate in this state, you need to operate within the milieu that's set by the COGCC regulations. So I do find this to be much more cut and dried at the end of 5 hours than I did at the end of a long time of reading through these documents. So again, I think even though it was a very long presentation, you did help clarify the issues in my mind.
Mr. Randall, does Commissioner Randall have any comments?
I will make brief comments. So as the new guy on the commission, I've been listening a lot and wanted to wait and hear from others, mostly to make sure that my sense and where I was coming to, I wasn't going to be a total outlier on this. I will agree with Commissioner Spielman. I think I find comfort in bright standards and undisputed facts. And that's what we have before us today. I think the staff did a good job presenting that. I, too, along with Commissioner Hawkins, would like to see these wells producing income that can be used to clean up the mess that's been there now for a long time. I don't have faith that that's going to happen with CM as the operator. So I guess just with that, I will agree with a lot of what's been said. I think the questions that have been asked have really informed my consideration on this. So, you know, it's taken a long time to get here, but I think it's been a good process in leading the commission to what sounds like a pretty reasonable decision if the vote goes the way it appears that it might.
You can ask it, whether anybody.
Answer whether or not it gets answered or not. So item 6 in the order, the $327,000 is related to the MIT test. Is that right? Not conducting the MIT test? Penalty. Okay. And the $64,500 is financial assurance.
No.
No? Okay.
In paragraph 7 of the order, 64,510 is a penalty for their failure to timely post the additional financial assurance required under Rule 707. The amount of financial assurance required under 707 is $210,000. That's it. Sorry, I just didn't say that very clearly. That's why I'm here. Thank you.
All right. And I apologize to Commissioner Allred if he thought that I was thinking that there's some gray area around compliance with 910-1. I don't believe there is. There is a bright line standard, and they need to achieve that. But I'm also conscious of what Chairman Compton said, is it may be a challenge to get there by this fall. So I guess I'll start with a motion, and then we can have some discussion about it.
Perhaps.
Perhaps. And it's always good to get a motion in a second so we can have discussion. So I would move that we approve the order as written with two changes. Is that if within the 30 days, as written in here, the operator conducts the MIT tests, that the cost of conducting those tests be deducted from the penalty. And if within that same 30-day period, the operator posts the bond, then the $64,500 fine is removed. And they use that money, one would hope that they would use that money towards cleaning up their dirt. That's my motion. Is that understandable?
Fairly clear.
Yeah, I would offer a second.
We have a motion and a second. Further discussion.
Thank you, Mr. Chair. Is it reasonable to expect that all the MITs could be done in 30 days?
Probably not. I don't.
I'm asking the engineers
Oh, okay.
and whether that's, especially given the time of year we're looking at right now.
Probably not. You know, if we make it 60 days.
Let me just say that I agree with you that probably not in 30 days is the correct answer. You obviously need a workover rig. You got to get to the
Just like
site.
this.
I mean, what is this, March? Where are we?
March.
It's
There may be-
March.
for all we know,
There may
there may
be
be-
access issues.
Yeah, 3
I mean,
phases.
this is exactly what we've been doing for 3 years, right? But you need to do this in June.
So maybe we escrow the amount and then they go out and do it in June and then they get to get some of the money back. It's a little more complicated. Maybe not.
30 days isn't realistic.
No, I agree with that.
In MIT questions, I usually like to ask Stuart.
Good policy. Yeah.
Can I ask the staff person? Mr. Ellsworth, do you have any comments on the amount of time?
Well, I would say 30 days is tight. You know, if I just kind of talk my way through it, you know, you're looking at like 30 days minimum to get a contract in place, 30 days to mow, and then scheduling the work. The minimum number would be 60. 90 is definitely more realistic. And then we're talking an area where you do have weather issues. So I think the time frame of June probably isn't, I know it's extended, but it's probably a realistic time to expect somebody to perform.
I mean, it's probably easier to get, right now, getting a workover rig out there is probably not too difficult. I'm more concerned about how much snow is sitting up there in Walden.
Okay, so let me understand. The motion is friendly amendment is a 90-day time period as opposed to 30 for the MITs.
Or a date certain. I think Mr. Randall.
I was going to suggest June 30th, just as
Okay.
you know, that's 90 plus.
Yeah.
a month.
As long as the staff is okay with that, because I'm quite mindful of their time they've spent on this already.
That was a friendly amendment, so we won't get into a battle about it. Roberts.
I'd offer a friendly second.
Any other comments, suggestions, questions?
I have a question on the first violation, where the operator has the option to either pay a penalty and perform the work or post financial assurance and negotiate a deadline to remedy the pits. And let's assume that the operator chose to post the assurance.
I'm sorry, I think I need to clarify it. I don't think that's the operator's choice, Mr. Commissioner.
Oh,
That
I
is
thought-
your choice of a remedy to
I
elect.
see. Okay, so we would, all right, so let's just say
Yes?
we chose.
It's the operator's choice. Okay, well, the enforcement staff has corrected me. It is the
This is an
operator's
A or
choice.
B.
operator's choice.
Right,
Just to-
my bad.
I think that all we're trying to do here is clarify, let's say that condition B, the financial assurance is the choice that's taken, and negotiate a deadline to remedy the pits. Is the financial assurance then returnable to the operator once the pits are remediated?
Not that I know of, but somebody does.
Actually, it would be, Commissioner, under, we're asking for this under Rule 702, which allows the commission to impose additional financial assurance for heightened risk. So if we got to a place, and I think we would put this in front of you again, but if we got to a place where things were looking brighter, then the operator could potentially ask us to consider returning that, or ask you, or we might bring it up ourselves. But yes, it's structured in such a way that it is returnable. The same is true in a slightly different path for the 707, the shut-in wells. If the shut-in wells come on production, they get the money back at $20,000 a pop per well, or whatever the math is. They get that back as those wells come on production.
So, I mean, I see that it's a lot more palatable to me because it provides a lot of incentive for the operator to perform that work and get the financial assurance back. I like that. So I can live with those conditions then.
You have a motion, a second, further discussion with these clarifications in mind.
I've got a question, and it probably ends up going to staff. But so we've got one motion in this order, trying to make sure I understand. So are we supposed to have 3 separate motions or one motion?
We have the option to do it 3 separate or do it combined, and it appears to me we're going combined at this point.
Okay, great. I just wasn't clear on that.
Right, Ms. Murphy?
That is correct. If I may interrupt, but Rich, I don't want to cut you off.
No.
Make sure that I have correctly captured the motion itself. And I believe the motion is to approve staff's order with 2 changes. One is within 90 days, the operator conducts the MITs. The cost of the MITs can be deducted from the penalty amount.
It's by June 30th.
June 30th. Thanks. Right, that's my note. Anyway, June 30th. The second piece is suspend the $64,000 penalty if the bond is posted within 30 days.
Yes,
Okay.
that's correct. And the fine is only, the fine stays in place if the work is done by June 30th. It's only reached by the amount the operator spends to do the MITs. So they will still, if it only costs them $300,000 to do that, they will still owe $27,630.
Correct.
Okay, so it's more or less a work for food program.
Is the penalty due date then delayed?
No,
beyond?
it's
Do it 30 days.
it's due in,
Okay.
well, no, the penalty due date is, the full penalty gets assessed by June 30th if the work is not completed. Does that make sense?
No penalty is due until June 30th, and the penalty due on June 30th is $327,630 minus the costs of performing the MITs.
Correct.
And they only get that deal if they've performed all of the MITs.
Yes, that is correct.
Okay, I think, now Mr. Davenport mentioned very early on that, or just a few minutes ago, you might have some other minor changes you wanted.
But we just want to make it clear that we would like authority to change if the findings of fact, the order has a number of different findings of fact, and if they don't actually comport with what's been said at the hearing today, that we have your authority to make those minor modifications before the order is finalized. So,
Blank checks were
yeah,
As findings of facts.
finding
yeah.
of
as to the
facts.
findings of fact, yes.
Okay. Hearing no further discussion,
Should we call the question?
we're just going to vote.
Sure.
Those in favor of the motion as presented, Ms. Murphy has that, and she understands it thoroughly, indicate by saying aye.
Aye.
Opposed, nay. Motion carries. Thank you very much. It seems like we often have contentious hearings. I don't know if that's the nature of the beast or not. Okay, we have any other business?
Yeah.
Not this evening. I did want to confirm that we'll be reconvening tomorrow at 9 o'clock. I believe Mr. Spielman will not be joining us, but Commissioner Holton will be joining us. And we're going to lead off with the discussion by Chris Eisinger for about 15 minutes. And then we'll jump into the Nighthawk hearing itself.
Sometime are you going to talk about, I think I read someplace that you want us to go to some far off.
Trinidad and Tobago,
Yeah, that's
I'll be making arrangements.
Any place
Yeah,
with a
exactly.
beach.
We'll conduct the hearing underwater. I hope everybody's a certified scuba diver. Yeah, we'll be in Trinidad in April, and Jen Bach, our hearing officer, will be contacting each of you regarding travel arrangements.
Thank you. Okay, we are, what are we, recessed until tomorrow, 9 a.m.